you, Right Honorable Speaker. First of all, I want to express gratitude to the Attorney General that he was able, unlike the tweets that we saw, which clearly said that these suspects, or some of them, would not be released, at least the Attorney General has indicated the willingness to have the court order implemented, notwithstanding, of course, instances where he must have read these orders upside down. Right Honorable Speaker and honorable colleagues, as the Attorney General was communicating, I have been really touched and concerned about a number of issues. The Attorney General knows very well that a person can only be held in prison on a valid warrant. The order of court, which literally dismantled, and I mean literally, not technically, dismantled the orders of the defunct court-martial, caused the warrants upon which these people were remanded to expire. But in the case of retired Colonel Dr. Kizza Besigye and Haj Obeid Kamlegea, even without the orders of the Supreme Court, the warrant itself was expiring on Monday, yesterday, and it did expire. So, my question to the Attorney General, currently for these people or persons that are being held, on whose orders, on whose valid warrants do they continue to be in prison? The second, Right Honorable Speaker, relates to the DPP liaising with the General Court Martial. What is the DPP's business? The DPP is empowered under the law to commence prosecutions against any person of her choice, provided there is evidence she has before her. The reverse is not true, that the DPP goes around fishing for cases. Number three, Right Honorable Speaker, but this time they are telling the DPP to be the one to go around fishing cases from persons that have been conducting business illegally. Do not forget that until Friday, 31st, there was a decision of the Constitutional Court which declared that this is not a court of law. So whatever they've been doing, they secured an interim order from the Supreme Court, and the order was to stay execution. Execution in this case was purely the transfer of files from the General Court Martial or from the courts martial to the civil courts. You could not stay a declaration. You can't stay a declaration. That declaration, that interim order was used by the General Court Martial, not DPP, to continue and to commence fresh prosecutions. Thirdly, Right Honorable Speaker, from the Attorney General's communication, I have not even heard anything to do with timelines. Timelines, so as long as they are doing their consultations, these people can be in prison now on orders of the Attorney General. Where, under the law, does the Attorney General get the powers to remand or continue an illegal remand or to detain? Literally what he has done is to amend the orders of court. Finally, I received information from the Honorable Semuju.
Thank you, Mr. Speaker. The information I wanted to give to Honorable Medad and Parliament is that yesterday our lawyers who represent Dr. Besigye and Ajo Bed visited the Commissioner General of Prisons. And he said his understanding was that people needed to leave, Besigye and Ajo Bed needed to leave his prison on Friday when the judgment became effective. And he said he was there seated waiting for the Attorney General. Up to yesterday, the Attorney General had disappeared from him. The last time this happened, the last time people were in Ruzira on no warrant was after the fall of Idi Amin. I interviewed Brigadier Sewagala when I was a journalist. And he said they were driven to Luzira, and they were told, you go there, the warrant will come. So effectively, I didn't know that things that were done by Army soldiers and after can be done by Honorable Chiwanuka Chiriowa almost 40 years later. That's the information I wanted to give you.
I thank you for this.
Right Honorable Speaker, for your wise guidance. Like I said, judgment was delivered on 31st January 2025. We received the signed judgment on Sunday, 2nd February 2025. We rendered advice dated 3rd February 2025. As you can see, the record speed. And we advised as follows, Right Honorable Speaker, that 1, all pending criminal trials in the General Court Martial should cease forthwith. 2, that the General Court Martial in liaison with prisons authorities should provide a list of all criminal cases involving civilians pending before the General Court Martial for onward transmission to the courts to determine the appropriate court to handle the matter. 3, the General Court Martial should provide a list of all pending criminal cases involving members of the UPDF pending before the court martial that fall within the categories of transfer for onward transmission to the courts for determination of the appropriate court to handle the matter. 4, the Director of Public Prosecutions is advised to liaise with the General Court Martial and the UPDF to take over the conduct of the ongoing criminal trials that have been identified for transfer. 5, the Uganda Prisons Authorities are advised to await the process above and orders of competent courts regarding any matters concerning detention of accused persons hitherto facing trial in the military courts. 6, the Ministry of Defense and Veteran Affairs is also advised to immediately commence consideration of the recommendations of the Supreme Court with a view to introducing appropriate amendments to the UPDF Act. Right Honorable Speaker and Honorable colleagues, I have also written to the Honorable the Chief Justice and requested the Honorable the Chief Justice to advising him that we have commenced the implementation of the court orders and sought for advice on the person with whom the DPP should liaise for purposes of effecting these orders. I thank you, Right Honorable Speaker.
Information relating to what you did not know that Honorable Chiriowa Chiwanuka can do. Right Honorable Speaker, I do not want to end at criticizing and critiquing my brother. I think I want to give some way forward. If I were in his unenviable position, this is what I would do. From Friday through to Monday, I would not sleep. I would require the information from the General Court Martial relating to all prisoners that are held on orders of the General Court Martial, now deceased. From that point, I would advise government to sieve out all political prisoners, matters which are not pure crime, and say, let us go and do the honorable thing of withdrawing. That someone can continue to be in prison, and the Attorney General is busy advising on somebody who was putting on a beret, a red beret, whether he should remain in prison. The third thing I would do, and for more than four years now, third thing I would do is to advise the police to immediately approach the General Court Martial, obtain all those files where we feel it is pure crime, a suspicion of crime, not suspicion of politics. Then I would advise that police would get those people from wherever they are upon release. But for you, you cannot say you are complying with the court order without releasing these people. At least do the ugly thing you've been doing of arresting them at the entrance or exit of the prison, the same way you've been arresting them from court. But any continuity in detention is illegal. Finally, I am concerned as a leader in this country. Immediately upon release of the judgment, Colonel Chris Magezi, who is said to be an assistant to General Muhoozi Kanyarugaba, issued a statement which he called the official statement from the UPDF, and it was clear and categorical. They shall not be released until General 7, the commander-in-chief, gives us orders to release them. And that is the basis upon which we challenged the constitutionality of the court-martial, because it is dependent on orders of the chairman of the High Command, who is General 7. Membership includes his son, who is now tweeting to say we cannot release. Mr. Speaker, for how long are we going to continue like this as a country? You have a dignified Attorney General. That man knows the law, by the way. Even when he chooses to disobey or to ill-advise, at least he knows the law. Now, we receive another statement from the president. Half of it was dignified. The second half was very dignifying. You hear from the president, and what he says that this country is not governed by judges and lawyers, where I agree. But this country is governed by a constitution. Anybody who does not want to obey this constitution should give us our peace by leaving. I am concerned about the tweets of General Kanyarugaba. You saw when he said that he was going to attack the mercenaries in Congo. A few days later, it happened. How are our neighbors going to take us? You crack a war inside, you crack a war outside. Why? Is it the Constitution, Mr. Speaker?
I want to sincerely thank you, Right Honourable Speaker. I think I want to make a humble contribution to this discussion. Right Honourable Speaker, the judgment of court was pronounced. I think the most unfortunate thing that some of us are doing is thinking that we can read this judgment off from the original text. We have excerpts of judgments which people are reading and not understanding the exact judgment. Yes, you can say the pronouncement of court that the judgments of this nature are in rem. It is true. But even for you to find somebody in contempt, one of the executing officers, it ought to have been brought to the attention of that person. We have the judgment which has been delivered by court. But what can only be executed is an extract of a decree or an order, which is the responsibility of the lawyers who are participating in the case. So, Right Honourable Speaker, we can say they are self-executing judgments. That is right. But when you read the orders of this judgment, and I want to particularly look at one of the orders, it says that all charges, this is the judgment of Winyidolo, all charges, page 194, all charges or ongoing criminal trials or pending trials before the court-martial involving civilians must immediately cease and be transferred to the ordinary courts of law with the competent jurisdiction. The word immediate is there. It's immediately cease and be transferred. So when you are reading the text, the paragraph, the sentence, it has a continuing. So if you say, this is a matter of interpretation. And where there is a dispute, as per the interpretation, it is not for Attorney General, it's for the court to settle that component. That what do you mean? Because court did not say release. If we are reading it to the dot, the court did not say release. Say immediately seize and transfer. Now, the process of transfer is a process. It is a process. So I think we need to understand it from that context. So we cannot castigate Attorney General for giving his view on all the processes that are being undertaken. But I think let's do our work. This is the real text. I beg to submit.
Thank you, Honourable Fox-Odoi.
Thank you very much, Right Honourable Speaker. Right Honourable Speaker.
Honourable Speaker, firstly, I'm glad that the Attorney General has correctly advised the executive to implement the court order. That's a good thing. However, I think that the learned Attorney General is misadvising the General Court-Martial. The insinuation in the remarks of the Attorney General is that Court-Martial keep holding on to these people until the DPP determines whether or not to take over this matter. I think that that's ultra-vires. Because for all of these people who are being held, Dr. Kizza Besigye, Obed Lutale, NUP political prisoners that have been held for over 4 years now, the Supreme Court said all those matters under the court-martial should cease with immediacy. Now, Article 120 of our country's constitution, which provides for the office of the DPP, when you go all the way to number 6 under Article 120, it says that in the exercise of their authority, the DPP shall not be under the control or manipulation of anybody. So nobody is meant to give any order or directive to the DPP. What the learned Attorney General seems to be saying is that now the court-martial is going to be directing the DPP to say, we have these matters, you take them up. That's against the law. What's meant to happen, Right Honorable Speaker, is that the court-martial is meant to issue with immediacy release orders for these people because the court-martial no longer has any authority over these people completely, release them, and then the DPP, in her choosing and in her investigations, if she determines that maybe there is any matter that's meant to come before the civilian courts, that can happen. But you see, the two courts are disjointed. Honorable, there is some information, if you'll allow, from
Nodul, then Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, first, I think as the Shadow Minister for Justice, I would like to convey words of acknowledgement and appreciation to the justices of the Supreme Court for coming out very clearly and boldly in delivering this judgment, which had caused great concern amongst the public and some sorts of anxiety. So I would like to thank the judiciary, the Chief Justice, and the justices who delivered this unanimous decision. Mr. Speaker, Article 126, Clause 2E, and I would like to read, says that substantive justice shall be administered without undue regard to technicalities. The learned Attorney General understands this very well. What he's trying to do is trying to delay substantive justice. The orders are as clear, and that court-martial, in my understanding, has not been disbanded. What I'd expected today or yesterday was for the court-martial to sit and say, we are now discharging all these persons that were before us, that at that time we thought we had the authority to try them. But now that court has declared we are now discharging them. And that would be the most logical step to do. We also know that courts rely on departments and agencies and authorities of government to function. Courts do not have the force to go and pick people, just like the speaker you observed here. As Parliament, we cannot go to prisons and open those padlocks. Courts rely on the goodwill of the executive in implementing the decisions that they issue. So I expected that the Attorney General, the DPP, the Commissioner General of Prisons, whoever is involved, to comply with this. The last point I would like to ask the Attorney General. You have read to us very good advice you have rendered. I would like to know whether you rendered that advice to the President. The President quoted you, that he called you on phone, and you seem to have given him an advice that does not match with what you are telling us here. Would you now? And Mr. Speaker, this letter from the President is in the open. I don't need to go through it. But he quoted that he got in touch with the Attorney General, who explained to him certain things. I understand that the Attorney General, being a party to the suit at that time in the heat of the moment, having lost that big case, you would have lost a little bit of your composure. But would you now clarify to us? And I've ever been to the Supreme Court as a litigant, and I lost a case. I know what it feels like. So I understand what the Attorney General went through. But would the Attorney General tell us
clearly, if this advice that he has told us here is exactly what he rendered to the head of the state, because what the president wrote potentially undermines the rule of law, undermines democracy, and I thought that it is incumbent upon the Attorney General to guide the president on the next course of action. Would you clarify to us and even lay, where possible, that opinion? Because this is not just advice. You said a legal opinion, and there is clarity on how a legal opinion is rendered. Would we see that here, Mr. Speaker?
Thank you. Thank you very much, Right Honorable Speaker. Right Honorable Speaker.
In my remaining 1 minute, I would like to cede ground to our Shadow Attorney General.
Speaker, first of all, the court-martial cannot sit. So it cannot sit to make any orders that you want them to make. That's one. Number two, if there are facts that you have, Honorable Medad Segona, as a senior lawyer, if there are facts like you have stated here, the best place to take them is to the court. Yeah? Yes. Secondly, Right Honorable Speaker and Honorable colleagues, Honorable Segona should know that as a practicing advocate, after you are successful in court, you extract a decree. If you think my advice is inconsistent with what the judgment said, you should at liberty to extract a decree, have the court sign it, and use it in the premises that you would like to use it. I have read this judgment variously, and you may think that I was sleeping. I did not. I spent time reading this judgment page by page, and I word for word. And what I have advised here, I did not get from my head. I got from the judgment. The matter under discussion is not the Court of Appeal decision. The matter under discussion is the Supreme Court decision. So reference to the Court of Appeal decision, which was appealed against, is misplaced. Now, there are no timelines. I agree. But we have sent the matters to the courts which granted these orders. The courts are still clothed with the authority to make any orders that they deem appropriate. Like
Point of order.
You see, Right Honorable Speaker, when the Attorney General speaks, he's the head of the bar. Everybody at the bar ordinarily should keep quiet. I agree with him that a successful litigant goes ahead together with the losing litigant to sign a decree, to prepare a decree jointly. If he was waiting for a decree, what was the basis of his advice? Number two, I am not aware, and he can now educate us, the law under which a losing or vanquished litigant would write to court to ask for which orders. The orders, Honorable Nwagaba says, is self-executing. Is the Attorney General, therefore, in order to mislead both the House and the country that the person who was in court when the judgment was being issued is waiting for a decree extracted by one party?
Attorney General, you want to make some clarification, if I can guide?
Right Honorable Speaker, I think where we are going here is a bit of a runaround, because I have told you my understanding of the judgment. And yes, and that's why maybe I lost. But what we are saying is that if you disagree with what I have written as what the court said, the arbiter is there. Now, finally, Right Honorable Speaker.
Procedure, Honorable Seshkuba. Procedure.